Mediation is an option when you're going through the legal process. It is a voluntary option. So, what that means is that in order to do mediation, both parties must agree. A mediator is a neutral person, which means that they are not making a decision, nor are they taking the side of one party or the other. The purpose of a mediation is really to try to facilitate an agreement when two parties have a dispute. So there are different methods for mediation. The kind of mediation that I commonly would do is meeting with the parties together. You can have sidebars with each party, but sometimes that might lead to one party feeling that um, you're biased toward the party where they told you information and you're not disclosing it. But the mediation can be used for any process in a divorce, custody, or support matter. So it's really whenever there's an issue that the two of you can't resolve, you can talk about that issue. It can be limited, meaning if you only want to use mediation for one aspect of your divorce, like custody, you can do that. Some courts will require you to attend mediation as part of a custody matter, but they're not requiring you to actually mediate. They're requiring you to go and learn what mediation is, because mediation is voluntary. And if you begin a mediation process and you meet with a mediator and you decide this process is over, you don't want to continue forward with the mediation, at any point in time, you can get up and walk out and say you don't want to mediate anymore. And that's why it's voluntary. It's also a confidential process, meaning that what is said in mediation stays in mediation. So oftentimes a mediator, if you contract with one out of court, is going to tell you that they're going to take notes, but that they're not going to retain those notes. And the reason that they don't retain the notes is because it is a confidential process. You want to be able to disclose to the mediator things that are not going to then be used against you. And a lot of times people don't understand the value of mediation if you don't reach an agreement. But a lot of times in mediation, you're going to narrow down your issues. So you might not come to 100% agreement, but you might, one, hear the other side's perspective in a safe space, and understand where they're coming from, even if you can't agree. Or in some cases, you might be able to narrow the issues down so that you resolve 90% of the dispute and only reserve 10% for mediation. So it is a very valuable process, but a mediator doesn't have to be an attorney, and a mediator is not allowed to give legal advice. So expecting to go to mediation and finding out what your rights are is not something that is going to happen. You would have an attorney separate and apart from your mediation in many circumstances. And the role of the attorney is really to just let you know and inform you what your rights are. But their role is limited. You don't have to bring them to the mediation session. You can, but it's encouraged that you mediate without bringing your attorney and just using your attorney on the side to guide you in making an informed decision, if any, in mediation. So it is a good, valuable process to explore because it can help you reach an agreement out of court. It can also help you start discussing the issues prior to a court hearing, which may, in many circumstances, be months or even a year away, depending on the docket with the court. Waiting for a court hearing can be stressful, and being able to come to a forum to discuss your issues with someone neutral and maybe coming away with an agreement is definitely a great option to consider when you're going through any type of legal process.